We're going to talk about some of the issues regarding mobile that are new because the devices do unique things. And just to give you a little bit of background on it, I want to introduce the panel first, and then I'm going to take you through a couple of slides, and we're going to respond to some of these tenets that we've come up with, or guidelines that we've been working with ESOMAR on. So what I'd like to do, though, again, is sort of introduce our panel. This is an open discussion, just like yesterday. I'll be walking around and would invite comments and questions and concerns and contrarians and challenges from the audience as well. So by all means, as we set these guidelines, we still need everyone's input. So what I'd like to do is go down the line here and have you introduce yourself. Martin, we'll start off with you.
Thank you. I'm Martin Tomlinson. I am the executive member for the Market Research Society in Singapore. I have to check my badge there because I also work for research now. We are in the process at the moment. My particular role at the society is to work within the APRC and come up with a code frame of best practice mobile research as well. The APRC is the Asia Pacific Research Committee, and that encompasses 10 societies throughout Asia. And the idea is to roll out a code of practice for mobile research amongst the societies as well. As part of that, the APRC is also part of a broader frame called the Global Research Business Network, which encompasses EFAMRO in Europe and UK and ARIA in the States. So that's a little bit about my background and my involvement with being up here.
Thank you.
I'm Dan Foreman. I'm Head of Business Development for LUMI. I'm also the President of ESOMAR, and ESOMAR works with the APRC and every other body to become the world reference point for market research. So that's why I'm here.
Hi, I'm Derek Ho. I'm Privacy and Data Protection Counsel for Mastercard for the Asia Pacific and Middle East region. So I'm really responsible for making sure that Mastercard complies with privacy and data protection requirements in the countries in those regions. As a caveat, as a lawyer, I'll probably just caveat right now that wherever things I say are just my personal opinion. Yeah, they don't represent Mastercards, and they're definitely not supposed to be legal advice. Yeah, you can go find some lawyer to give you some legal advice on privacy requirements.
Perfect.
Okay, hi everybody. Welcome to KL. Right? I'm Barry Hui. I'm the president of the Market Research Society of Malaysia. So whatever I say this afternoon will probably try to reflect the views of our market research practitioners in Malaysia. I'm the current president of the society. Just thought of that introduction.
Terrific. And my name is Mark Michelson. I'm the executive director for the MMRA, the Mobile Marketing Research Association. And just to give you a little bit of background, we formed this association after the meeting in Atlanta, the MRMW meeting in Atlanta. We formed it specifically, it was one of the first research organizations formed around a channel, a media of data collection. We have the QRCA and Mystery Shop Providers Association, which are sort of around somewhat methodology, and I created MSPA and been very active with QRCA. But we created this one because the conversations around privacy, particularly in Atlanta, kept going on. What do we do about passive data collection? How do you inform consumers to turn things off? How do you know that you're not giving up someone's identity across a border when you have a photo or a video? What do you do about masking? How do you protect that? And just to give you an idea of the extent of what I've learned, and you guys correct me if I'm wrong on this, but the privacy laws around the world are different by country. Even in the EU, where they're supposedly together, you have 27 different versions of privacy laws. Privacy and privacy are interchangeable, by the way. And for instance, in Europe, right now, it's illegal for you to go out, take a photograph in a public place. Let's say you're at the Eiffel Tower, you got your family in a photo, and you happen to get a whole bunch of people in the background, children, etc. And you can see their faces in your photo, and you put it up on Facebook, guess what? You just broke the law. Did you know that? You did, because not only do you have personally identifiable information, which is the face of the person, but you also have meta tags in there. And this is part of what is going on with mobile on this slide up here. I know you guys can't see this very well, but I'll read it to you. So Kristen Luck at our conference in Amsterdam referred to this, and she says, OMG and WTF. Those are the big issues around mobile and why privacy is important. So OMG, online tracking data. So it's passive data. It's constantly being monitored, as we heard yesterday, by some of the carriers and things like that. It's always there. Metadata in photos. Every photograph, every bit of digital media you take can be dissected unless things are like GPS are turned off. But you can take a photo and you can say exactly where it was taken and when it was taken. So that's why it becomes personally identifiable as well as illegal, because you know where they were and what they were doing and what time it was. So that's scary stuff. Geolocation, we've all are familiar with the phones being able to mark things with geolocation. So that's OMG. On the other side, we have wandering device IDs. These things are starting to link with each other. Devices are talking with each other. So as we have multiple devices, those sometimes can be linked back to an individual. So even if you have 3 or 4 things, you can tie it back. Too complex privacy policies. How many of you have looked at your Facebook terms and conditions in depth? Everyone? No one? How about Google's? You looked at Google's terms and conditions? Well, I got news for you. You've given up your firstborn and the right to everything you personally own, I think is the key. Seriously, the policies are unwieldy, so that's been a challenge for us too. And finally, fees for data streaming, which is the F on this. It's not quite what you thought, OMG and WTF. So, what we have here is essentially an issue that privacy, because these devices do things that we've never been able to do before, the laws that are out there are archaic in some degrees, but they're also there for a reason. In Europe, my experience is, and what I've heard this, and maybe correct me if I'm wrong, but in Europe, privacy is actually a right. It's protected as a right. And probably in Asia too. I don't know, maybe country by country, right? Country by country. In the US, privacy is not legislated. It's not written into any type of legislation or law. So it's not a right to have privacy in the US. Although on a state-by-state basis, things like surreptitious recording or recording telephone conversations is on a state-by-state. Does anyone remember Bill Clinton and Monica Lewinsky? Well, if whoever it was, that lady that made the phone call, if she was in like 10 miles difference, it would never have been an issue. But she got in some kind of trouble because she actually made the call from a state where it was illegal to record the conversation. So these laws do exist. They exist for a reason. And for legal reasons, we have to not only adhere to that for our own protection, because there have been cases where it's just not a good idea to go out and share someone's information without their permission, number one, no matter what business you're in. But as researchers in particular, we have a responsibility to respondents so that they'll continue to share information and share their lives with us. And ESOMAR had some mobile guidelines when we first created MMRA, and these guidelines were on mobile, and they were largely sort of tied together to the online guidelines, right? And my favorite, one of the guidelines was, if you reach someone, they're driving down the road for a survey, and you reach them on their mobile, have them pull over to the side of the road to continue the survey. And that was pretty much the extent about a year ago. And ESOMAR is also really sort of the larger entity that can do something about something if we get in trouble. You know, if we start getting attacked as an industry, ESOMAR is there with resources and strength to do that. MMRA, on the other hand, we had some people that had different skill sets that were maybe not part of a task force yet. So we brought in qualitative experts. We brought in some passive data experts from groups like Arbitron. We brought in people who were also in survey research. So people who dealt with technology as well as other elements that weren't not part of the earlier task forces. And so we expanded that out into guidelines that fit within the existing ESOMAR guidelines. These existing ESOMAR guidelines, how many pages was it? It was like 19, 20 pages long. We ended up creating these guidelines. How many of you are going to take time in your business to read through 18, 19 pages of guidelines so you know exactly what you should or shouldn't do. I imagine probably a lot of you are the same ones reading your Facebook terms and conditions. So what we've done, and this is where I want to begin the conversation today, what we've done is we've taken those guidelines and tried to condense them down. Ideally, we were looking for 5 commandments instead of 10, but we ended up with 10 commandments. And these commandments they're on the screen, but I'm going to read them out so that our panel here can understand. And I want to have a discussion around this as we go. So, first, be open and transparent when asking people to participate in research. These are commandments to us as researchers, as technology providers, as clients. Be open and transparent. Always specify the purpose of the research, the information you plan to collect, how you plan to collect it, how it will be protected from disclosure, and with whom it will be shared in what form. Is that possible? Is that possible? How about with you, Barry?
Okay. First of all, just let me give a little bit of background. This is really a timely issue because in Malaysia, effective 1st of January, we've got a Personal Data Protection Act that's being enforced. Malaysia got a Personal Data Protection Act that was legislated in 2010. It took them many years before now we're going to start implement it and under the legislation. So certainly this is a very important issue. In regards to specific issue that you talk about is it possible to inform respondents?
To be transparent and open in everything.
I guess from a research provider point of view, we've always, in many ways, as part of our screening process, we do inform clients about permission. We do get permission. And at the same time, we also screening them, they are the right respondents, and if they are willing to participate, we actually do tell them what the research involves. Now, however, there's one issue which I think that a bit sensitive is, are we at a point where we need to also disclose the client? Because in some projects, you're not allowed, you're not supposed to reveal the identity of the client. That's where I think maybe a big issue for us to be fully disclosed in a sense.
What do you think? Here's a client.
Well, just going back to your question of whether it's possible, I think it's necessary. Really, that's the key point. For all the laws in Asia and anywhere around the world, it's necessary to tell these people about the purposes, about why you're collecting it for, and for what purposes which you're going to use it. And there is a reason for that. I mean, it ties back to why you're doing it. You want to build that trust so that people can continue giving you the information. You will continue being open to giving you, their opinions about something which your client's interested in. If you don't build that trust, and you break that trust, and that trust, trust is a very curious resource. Yeah, it's as with all resources. As you keep on using it, it gets depleted. But with trust, the more you use it, the more it gets built up. Right? But when you break it, it's very, very difficult to put back. It's very difficult to unscramble a scrambled egg. So it's it's not just is it possible? No, it's necessary. And 2, you got to find out how to do it. Now we have difficulties now these days with the mobile phone, right? You have a 4x4 screen, the smartphone, or let's say you're using a Nokia screen, which is really smaller. How are you going to fit that privacy policy into that 4x4 screen? You'll be scrolling down and scrolling and scrolling and scrolling. So there was a great discussion, I think, by, I don't know whether he's the former FTC chairman, but I don't know whether he still is, sorry. But he mentioned last year that privacy policies should be like nutrition labels. Have you seen nutrition labels on packages of food, right? So it should tell you in a snapshot in a real small box. I'm exaggerating, right? But it should give you in a snapshot what you are using, what are you collecting, what you're using it for, and What are you going to disclose? Who are you going to disclose it to? So that people can understand. I think for those people who have websites or are able to analyze how many people visit your privacy policies. I mean, you can use, if you use Google Analytics, and you can see how many people actually read those policies to land on that page. I can all probably agree with you that, not many people do it, right? You'll just click, I accept, and I don't even click on the link to go to the privacy policy. So there is a need to make it, yes, open and transparent, which, by the way, are the exact words which the Australians use in their Privacy Act, open and transparent. And you need to do that because it's necessary, and more importantly, it builds trust.
How about revealing client identity?
As in to the
respondent. Yeah. At any point, is it? Do you think that at some point it might be that you do it, because it's hard to do it up front if you're doing an awareness study, obviously, or you don't want to know, you don't want the respondent to be biased.
Yeah. So that depends from country to country. In different countries, the requirement would be you have to identify who the data controller is, and it's different countries have different notice requirements, and some of them would say that you have to identify who the data controller is. And the term data controller is a legally defined term, and there have been lots of debates as to who is a data controller. You need to go through a whole legal analysis there as to who that is. So if you're just an agent acting on behalf of someone, who, in this case, the client, the agent may be a data controller, and the client may be jointly as the data controller, because both of them are determining the purpose and the means for which you are collecting the data. So I can't give you a straight up answer as to whether you can or cannot give the name of the client in that case, or whether, sorry, I think the answer is I can't give you a straight up answer as to whether you must give the name of the client out to the respondent, because that really depends on this person.
Let's say the trust is broken. Who do they sue?
Sorry,
Let's say someone's privacy is broken.
The first, in most situations, they are not going to sue you directly. Most people, when they receive, most people, when they think it's a problem for them, or they're going to suffer some loss, or they feel just annoyed at it, they usually don't have the resources themselves to pursue a large company, especially if they're out of jurisdiction, yeah? Or especially if they're not going to get anything out of it. So the first port of call is always with the regulator. And you would see most people complaining to the regulator rather than suing you directly. Yeah.
Okay, but it also go to social media and then turn it into a firestorm.
That's a reputation risk that you have,
Right. Okay, Dan, you've been in mobile a bit. So to his point, and our point number 2 that you guys don't see here because it's behind you, but is always provide your privacy policy in a form that's easily accessed and understood by participants, particularly if you're on mobile. Now, you've just deployed a survey. It's on 5,000 people across the world. How do you do that?
It's tough. This morning I logged onto my Wi-Fi. I accepted the terms and conditions. Yesterday I signed a form I didn't even read to say you can video me and use that how you want. Now, it was only one page, and I didn't bother reading it. None of us check any of these terms and conditions. So yes, there's a need to be open, transparent, to make all your privacy policies clear. But the real challenge is to somehow ensure that people process that. And that's a big challenge. I'd love the labelling analogy to happen. Make it really clear that this privacy policy is good for you. You should consume it. That would be great. But we're a long way from that at the moment.
Mm-hmm. And Martin, you represent the societies. These are the individuals, the smaller companies, if you will. How do we do that?
I think with mobile at the current state where we're at, I know listening to people's presentations over the course of this conference, a lot of people are recruiting and they're recruiting to get their mobile respondents. Now it's in that recruitment process that I feel that's when we're best to be able to advise them. And they're not necessarily recruiting randomly, they're recruiting from panels, they're recruiting offline sources. So there's a step of contact that's happening before them. When we start talking about random respondents, that's when things start to get a lot more interesting and a lot more difficult. The recruitment process, for instance, if you're recruiting via a panel, you can already utilise the fact that you're on a bigger screen to start with and recruiting them into the mobile survey. So you can have the policies in place, you can have extra information that you have there, no problem, and it's much easier to be delivered because ultimately the question that you're asking applies across all methodologies. It's not necessarily a mobile specific question. I mean, we have to do the same with online, we have to do the same with other methodologies if we're using sensitive data. The only difference with mobile is there's a lot more sensitive data, and I think clients should be, researchers should understand clients and what they specifically want from that, and also be able to pass that back to the respondent to be able to understand, to be able to pass the right information back to them, what we're actually looking for, what we actually want to be, what we're actually finding from you as a person. I've lost my train of thought, sorry. But my point is that if the respondent has clarity and they're understanding what the involvement is through the recruitment process, there's not going to be too much of an issue. We already do this with other methodologies. Translating it into mobile is probably going to be more about the randomness and how we can create it to happen on a BlackBerry screen, a smaller BlackBerry screen. I think time will tell how that works, and I totally agree when it comes to having a very small privacy policy that basically covers as much as we possibly can. It's probably a very good way to move forward with. But from that end, client name, I'm not too sure if we should be necessarily doing that. I think perhaps at the end of the survey, if that's the way, if that's really what we should be doing, but I would challenge that. And so we don't necessarily need to do that. It should be up to the researcher. The researcher is operating on a code of practice, and at the end of the day, that also is about the researcher protecting the respondent from clients who want to potentially use that data in ways that it's not really designed for.
Good point. Now, we didn't, I see everyone's grabbing a mic up here. We might need more mics up here if we have them. Now, we are not actually advocating that we reveal client name, okay? This commandment doesn't say reveal client name. It just says be open and transparent. It could be interpreted that way. The next area that I want to touch on here, and if you jump right in any time, but the third point is that any information that could be used to identify a participant must be kept securely and only used for research purposes, and that includes photographs and videos. Now, that's the key point with a lot of this stuff. There's a lot of use of photos and videos. I just did a study where I had over 1,400 photos taken inside people's homes. And this was dealing with a lot of stuff like their bedroom, their kitchens, their nurseries. Also going into stores and taking photos, and whether or not that's allowed or not. But the information, and they had to do videos where they basically did like a self-interview. They had to talk on the video and show some of their personal style and their dress and their apparel. Now, the client, of course, they want to see this. They want to see the person, big time. But with this guideline, I have to actually smudge their face. I can't show their face, especially if I'm sharing it across borders. Now, in the U.S., I actually can, because there's no law on it. But this guideline would say, nope, that's not allowed. What are your thoughts on that? Is it possible to smudge every photo, to get permission and opt in, every video you take? Has anyone ever tried to smudge something on a video? I'm not very good at it, I gotta tell you. So it's a guideline. Is it doable? What do you think, Barry?
I think the issue here really is about permission and also disclosure or non-disclosure. So if we already secure the permission of the respondent to participate, and if you already inform the respondent what we're going to do, the purpose of the survey, and that this particular task that the person is doing may be shared to the client for for the further understanding. The permission has already been given by the respondent. Clearly, I don't think I don't think we are bridging anything major here, unless there are legal implications to the privacy.
There are, actually. And our point 5 is never share any personally identifiable information unless there's a formal agreement in place, okay? And that the information will be protected from disclosure and used only for research. Now, however, there are laws in Europe that say you can't send, I don't care if you've got permission from everyone, you can't send any kind of personally identifiable information to a country that doesn't have the same code of law that we have. So if your client's in the U.S., you can't send it, even with the opt-in.
A lot of issues that you brought up over there. I think we just move back one slide.
Yep.
So the first point which you raised was that it should be stored securely, right? I was just remarking over lunch that, 2012 was a great year for security professionals. It was called the year of security incident breaches. Security incidents. 2013 would see just an escalation of that, right? And most laws, all data protection laws require you to maintain your personal data and the personal data of individuals securely. And there are no two ways about it. You just have to do it.
Is it possible? I mean, really?
So obviously, and it came out during lunch as well, that there's no absolute system, right? Come on, right? We know that Windows has the blue screen of death. Every technology is going to fail, your system's going to hang, but you're going to have to take reasonable steps, right? We're using commercially available software, security software, and implementing measures, giving training to your people that, yes, you put all these steps in place, and that's as best as you can do. But you have to at least take those steps. Now, the question was, is that possible, right? The regulators now, there's this growing trend around the world, and you will hear this term being bandied around. It's called privacy by design. So you just can't take one project and one campaign and just say, I'm just going to look at it as and when the question comes about. But the privacy by design requires you to go from the life cycle of the data when you collect it, how you store it, how you transfer it, how you use it, who you're sending it to, what systems you're using it, how long are you retaining it, how you destroy it. The whole life cycle of the project and the data must be looked at. And privacy by design also requires you, not requires you, it's a good thing to have, and it helps to address the problem. Is it possible? Because what you're doing in those situations is to take reasonable steps to put in place so that you can identify those issues.
So you have to document a chain of custody.
Yeah, correct. So in most organizations which have a lot of data, you should have, I believe, a data inventory. You should at least know where it is. When the fire breaks out, you should know where your valuables are, right?
Yeah.
So in the same place, in the same thing, information is, I've heard this, information is the new oil. Big data is the new oil, right? It's such a great resource, and if you don't protect that resource, someone else is going to take it from you. And when someone else takes it from you, I just go back to my earlier point, people just won't trust you to use that resource or collect it on their behalf.
Mm-hmm.
Yeah.
So moving to the next one here, and this is again, not necessarily privacy, but it does relate to using mobile, and that is never ask participants to do anything that might risk their personal safety, compromise their confidentiality, or damage their device, okay? And in particular here, you're thinking about, costs for sending something, or you're uploading a video that's 30 minutes long and it takes, a week to send on your 3G. And also, it has to do with capturing someone that that compromises their confidentiality. I'll give you an example that we ran through in our task force, and this was an ethnographic study, self-ethnography. So some person obviously sending a photo in to the researcher. He's sitting in his home, he's got a photo, he knowingly sends it, he's already signed the opt-in agreement, and the researcher's looking at this photo and he sees a mirror image, and there's a mirror in the background of this guy. The guy never saw it. He sent the photo in. The mirror has, he can see his wife naked in this, So he's like, oh my gosh, I should inform the guy. So he informs him, the guy's embarrassed, But he's like, I need that destroyed. Well, it's not easily destroyable because it exists on his device as well. And on the chain of custody goes there. Now, he never let it go to the client, but it could have. And that's the point 6. Any thoughts on that? How do you monitor and manage that when you're dealing with 1,400 images?
You can't. And to some extent, you have to accept that these things are inevitable. These things will happen. And in today's world and in tomorrow's world, the complete right to privacy and anonymity is gone. And whether that's necessarily what we want to legislate for is debatable, but it is inevitable. Because you can put all that stuff in place and you can do your best to delete something, but there is a chain of custody. Somewhere else, perhaps not in your research project, those same photos will exist and they will be accessible by other people and may have been taken by somebody who isn't a member of the MMRA, for example, or some other body, or is in a different country. So all these things will continue to be there, and these things are best practice, they're guidelines, and I'm not sure that there'll be some things like that you just can't do anything about, because we're not in a position to destroy that line of custody. It's not something that we have access to.
Mm-hmm. More thoughts?
Yeah, I would agree with Dan's comment regarding that. So some of these guidelines, the commandments here, I think could be a bit too stringent on ourselves. You take the 6 there as a good example. For example, if you want to use the 6 strictly, forget about mobile research, using mobile technology as a research tool, because you never will be in a position to ensure that the respondents are at risk. So I think if you're going to adopt that, that's going to be a tough order for the research fraternity. Even the early one, the point number 2, was also pretty stringent. I think the point number 2 was on the case of always provide your privacy policy. I think adopt a private policy, yes, certainly not an issue. I think every research organization should certainly adopt a strict private policy in their practices, but always have it ready, use it. I'm not sure whether that's practically necessary in that sense, because sometimes respondents are not really that particular, for example, so why go the stringent route and
Scare them off?
Scare them off and put us in more barriers to how we're going to go about doing better research for our clients and etc.
Mm-hmm. You have something more there?
So just a comment. With the privacy policy, I actually don't think that's going to be too much of an issue. If you're using an app base, it's just a link. We do it already. I can't see there be too much issue with that. I think the technology is very similar ultimately to online in that sense, and there's still a lot. I think some of the questions here, we could read really in depth into them, but again, as you point out, it's best practice ultimately. We need to be very ethical, and we need to stand away from the Googles and the Facebooks. If you've looked at Facebook graphing, it's scary stuff. And we want to be able to say, this is what we do, this is how we do things, and we are a self-regulating industry. There are probably going to be situations where there will be challenges, and it will be this that we agree on now that's going to be, we can refer back to and hold us in good stead.
It's interesting. You say stand back from the Facebook and Googles. They're in the insights business now. They're in the research business. They're doing surveys. They're giving away their insights, actually, as we found out yesterday. So how do we not embrace them? How do we say we're different than they are?
I don't think we don't not embrace them. We do embrace them. We all sit around the table together. We get them involved in these kind of discussions. That's essential. So GCS is designed for mobile. They should be consulted and adhere and help us redefine these if they need to be redefined. And we're self-regulating, so will they be. And we want them to help grow this business. And they will. This is a big part of the future of research is mobile, and Google play a part in that. And if they can't adhere to the guidelines, then maybe we should question whether the guidelines are the right guidelines.
That's what we're doing. Or it's an early phase. Now, we do intend to revisit. This is not actually published yet. This is still early drafting stuff. We're hoping to complete this task this month, actually. But we do fully intend to revisit this annually, if not even more frequent, as technology changes and as laws change around this issue. The next point, number 7, really is all research anyhow, but never conduct research with children without gaining consent. And then number 8, I think, is pretty obvious. Always understand and obey all local laws. How many countries are you representing? Yeah. And SMR is in how many countries? Okay, so where do I go to find out all the local laws for every country I'm doing research? Guy, you do a lot of work around the world. Do you know all those laws?
They're all very different, they are. And you asked a question a bit earlier about whether or not we have to disclose the client. In some countries we do have to disclose the client. So you have to make sure that you get some of your important questions up front where you don't want to bias an answer, but you have to say who the client is. Germany, I think, springs to mind as a market where I think you have to say who the client is. There's no getting away around that.
And the local laws. Ignorance of law is not an excuse.
No, absolutely not. I did have I was got a slightly devil's advocate question here, but I did want to just get feedback of what people think. Are we actually trying to fight an impossible task, an impossible endeavour? Because if you think about where technology is going, and if you think everything's becoming faster, information is travelling directly. Soon we're going to be wearing Google's goggles, walking around, information coming straight into our eyeballs. So actually what we're trying to do, is it impossible?
The question is.
It's impossible to be specific, because as soon as you put a stake in the ground, it's kind of out of date 1 minute later, because things do travel so fast. And you said yesterday the most exciting thing about these kind of events and this industry is that it changes every day. So anything that we put down would also have to change every day. But what we're talking about here, I think, are just some principles. And those principles should be sufficiently broad, sufficiently nebulous, that allows us to recast the principles and the framework regardless of the technology and regardless of the advances, so that the principles we agree now will broadly be the same principles that we're looking at in 20, 30 years.
And just to pick up on Dan's point, most laws are drafted like that. General principles, they are technology neutral. They don't tell you what standards you have to adhere to, with the exception of India, where they actually specify the ISO standard which you need to apply for security. But most laws in general have general principles which you have to comply with.
At the ESOMAR 3D conference in Amsterdam back this fall, I actually used an analogy. I says, the roads are being paved so fast, there's no traffic lights or speed bumps in the way yet. So as the accidents happen, these things are going to be written as they go. Well, certainly. How about for our industry, though? Our next one here, our point 9, is take special care in the design and delivery of any downloadable or web-based app to ensure they're bug-free, easy to use on small screens, do not alter the setting of the device, only collect information for which the participant has given explicit consent, do not denigrate performance of the device, easily uninstall at the conclusion of the research, and never use an app that might be considered spyware. Wow. Okay, my technology guys, you doing that? Anyone writing some, even combining this in the next one here, and that's passive data collection. By geolocation tracking, web browsing behavior. We've been talking about that all day yesterday, passive data collection, how wonderful it is. Always ensure the participant is aware of the type of information being collected and how it will be used. How do we do that?
Well, you can't, because this is unobservable behaviour, and as we know, we're poor witnesses to our own behaviour. So, and also to some extent, you can't make clear the intent to which you might use something. Consider as an example so I think we'll hear a bit more about it later, but the emotional monitoring or the biometrics, the things that are happening that you're not consciously aware of. Mm-hmm. How on earth can you get informed consent about things like that? And it's true for passive as well.
Yeah, yep.
You know, just picking up on those points about how technology is advancing. You know, if everyone has seen the movie Minority Report, right, where Tom Cruise walks down the corridor, the ads recognize the retina, focuses on the retina, knows that he's Tom Cruise, whatever his name was, and displays an ad saying, you know, the BMW ad or whatever ad which he has.
Google does that to me every time I log on to, my findings. And I think Facebook too.
But going back to the point, so just looking at looking to the future where technology, where it's going, where facial recognition and facial coding is going to be more and more, popular. How do you present notice in that situation where someone's walking down the alleyway or the subway and the ad pops up because he recognizes that you are Mr. So-and-so? That's a problem which, okay, so the laws aren't going to go away, they aren't, right? We can stop, I think, wishing it away. So we just have to look at it, look at the principles, and see how best to apply them, and whether exceptions apply in those situations that you have.
Okay, I want to move to the next area, and that is our commitments to respondents. These actually have some sub-bullets as well, but I'm just going to run through them pretty easily. This is something we think is the nutrition code that could be down, okay? We got it down to, I think it's 7 points. So number 1, your participation is voluntary. We will protect your personal information. Participation is free. In other words, you shouldn't have to pay for any kind of wires or your charges to your phone. Your safety is important. We will protect your device. We will always obey the law, and we are here to help. So you would have a service desk or something like that. Is anything missing? Anything missing, or do you think this is too nebulous?
I like the first one, your participation is voluntary. It kind of is because so every time you go on Google somewhere, at some stage you click and I accept the terms and conditions. Beyond that, I haven't volunteered for anything. Yet all my data is being recorded, tons of profiling is happening, they're serving certain ads to me and so on. So it's kind of voluntary, but it's implied voluntary. And I think that will get even more fuzzy.
Yeah, the one that's not on here, we actually debated quite a bit in a task force was, inform the respondent how to turn this stuff on and off. Okay, so if you're having an affair down the street, you can turn it off so you're not being tracked on Google Maps. You don't get caught. Whatever that is. But knowing how to turn it off and knowing how to turn it on. So that was one we're still debating. Does that impact research design? Does that impact privacy design?
I just wonder if that would come under voluntary, so you could voluntary opt in and out at any stage. Difficult for us as researchers to be able to manage that, of course, but maybe it's more of a technological issue. But I think the other thing with was probably so I can't read it from here, but the one, sorry?
Sure.
Participation is free.
Yeah.
It's relatively difficult because different markets have different billing systems, whether they're on prepaid, whether they're on a contract plan, whether it's an unlimited plan or a pay-as-you-go. Especially when we start looking at random respondents, those that have opted in via hash codes, etc. So that could be a very difficult one for us to manage, I think. And I'm not too sure how we would actually go about doing that, but maybe the guys here would have a better understanding than me.
Great point. You know, if you take a picture of something as you're out, you know, and then you take you a survey, and then all of a sudden you're paying for that line, is it free? Right. Good. Excellent point.
Yeah, but somebody talked about Dunnhumby yesterday in Tesco. So every time you buy something, you're forming part of a very valuable data set. And this is a commercial business that makes a fortune, and some people have done very well out of it. And this is something that will be mirrored for sure all around the world, that same loyalty scheme. So every time you buy something, your participation isn't free. And sure, you get a benefit because you get your can of soft drink or something, but it's not free participation.
The panel, consumer panel data is correct.
I'm sorry, what was that?
Consumer panel data.
Mm-hmm.
The respondents are given some sort of compensation for providing feedback. So I think overall, I mean, not any. It's certainly a good commitment. The only point is the bullet number 2. That's the participation free. It's the tricky part.
Mm-hmm. Mm-hmm. This is cost neutral. That's a good point. Cost neutral. Call Red Baker and tell him that phrase. So what I want to do is I hope we've stimulated your thinking around this a little bit, maybe scared some of you. I don't know. Are we preaching to the choir? Is everyone in? Anyone concerned? Anyone disagree with some of this stuff? Come on, don't be shy. Rob, I know you're vocal. Oh, over here. Great. Alistair, you're a perfect candidate for this discussion.
Just a point that we're kind of making life hard for ourselves, really, because lots of other companies don't think about these things and do it, and they're our competitors. And so we're not going to be able to innovate, is the point.
Good point. And there's a lot of them that aren't thinking of themselves as researchers who are now playing research games.
I think the industry has always got to take a sense of responsibility about education, so making these principles aware. A lot of your principles that you put up there are very much the existing code of behaviour that applies to all of the research. Having been part of Market Research Society committees over the years, it's been behoving on the industry to make sure its members are aware. Every researcher that comes into the industry should be aware of all of these principles. So, and also, in a number of countries, they've done campaigns to educate respondents. A lot of it is about self-regulation then, where like Australia is a good example with the privacy principles. The fact that the industry had a self-regulatory quality system in place stopped us from being roped in with the direct marketers. But it's all about self-regulation. The key component that is then to follow up on compliance. So, you know, with an ISO, the new ISO has privacy in it. I believe that the whole industry should be adopting ISO 20252, and we have self-regulation and we have compliance to ensure that we are following through on it. And that completes the loop of the education.
That's a great point. Education is, I think, key, because that goes back to the point about individuals. What can you do to help the individuals understand this and protect themselves? From my own personal experience, at least in the mobile world, in Australia, you had a situation where the industry was very much self-regulated. This is a very specific example for premium rate services, where people were receiving premium rate SMSs, charged at whatever $2 or $2.50 per SMS to receive something. So the industry was very much self-regulated. But the problem came in when, some participants in that industry just didn't follow the rules. They didn't follow it, and it came to a situation where the complaints started to go up. And as you know, the regulator is very sensitive to complaints because they would hear it from, many stakeholders, the media, the politicians, consumer bodies, and they'll all get on the regulator's back. What are you doing? Are you sleeping on the job? Oh, wait a minute, we have this self-regulated code. That's not working. So you get, when you have these participants who are not playing by those rules, or or who are maybe not educated about whatever principles that you have, then you're going to have that problem where you'll be going down the route of regulation, which eventually that was what happened in Australia. The self-regulated code was put back, reviewed. The regulator said, I've had enough of this. I'm going to put in my own requirements, and they issued a new code, which is now enforceable by the regulator.
Yeah. So I was wondering if we what you guys think about if we start creating some kind of organization which will handle these kind of cases retroactively. Because although I agree, proactive prevention of these issues is really great, education, those laws, code of ethics and stuff like that, but there are always going to be companies who take advantage of this just for short-term gains, quick gains. And if we really want to protect the respondents, maybe we can create some kind of committee, some kind of organization which will be funded by all the companies, which will protect the respondents afterwards if they are offended. Because like auto industries, I know in California, there is a code that you have, if you have an arbitration, if you first have to go to these organizations, designated organizations, you can't go directly sue a dealer. First you have to go to this organization and see if they can settle your arbitration, and if not, only then you go to the court. That will protect both companies and the respondents.
Excellent point. We're almost out of time. Did you have something, Rob?
Sure, yep. Just briefly. We've just finished developing a mobile app for about the last 9-10 months. We had a long discussion about how we should help. We're in a unique position that we deal with both the end clients and market research companies. And we decided that we felt it was our responsibility to educate both the end clients and the market research companies about how best practice should take place. So a finishing up of our rules will actually be the guidelines that you guys produce to ESOMAR anyway. So, but I think that should be the rule. If we're the vendors, we should take responsibility to educate people. Otherwise, there's a good chance they're too busy doing other things. They'll never get educated.
Yeah, precisely. And to your point, these were adopted from ESOMAR's existing guidelines. So a lot of this is there, but the things that are specific to mobile that we added to it had to do with the photos, the videos, the passive, the GPS or geolocation. And those are the areas where we really try to make sense out of it. The other thing was where you're taking these images. You can't take photos in government buildings, for instance. Certainly not in the security line at TSA. So you don't ask someone to go do that. You don't want them to go into a place where they're going to maybe get their device taken away, like at an airport. I had a friend that was taking a picture of a plane just in Milan, right, or Bergamo, right? Police immediately came up and tried to confiscate his camera, his phone, his camera phone.
Sorry. But if you do that, if we have such regulations on ourselves, guess what? The inside bit is going to be missing because some of the photos taken are contextual. We need to see where the respondents, the consumers are doing activities in those places, and if we say, just in case you're in this particular area, please, where is the inside? We'll be missing some bits of information.
Yep. And these will be changed as we go. We fully anticipate the whole sensory thing, Google Glasses, all the new things that are coming into the technology of mobile. Fully anticipate it to be changing, shifting, adjusting. Dan.
The passive data collection guidelines have existed long before we start talking about passive measurement using mobiles. Mm-hmm. And the same principles again. So you're always observing people as part of the role. That's what we do in qualitative, and when we go and stand in stores, or we observe behaviour in many places. And historically, we violated a lot of the guidelines on PII, and it's kind of an impossible thing to regulate.
Are we any different than a security camera?
Not at all.
I don't really have anything to add. I'm more interested to hear about this myself as well.
What about that security camera analogy there?
Well, in many countries there are laws regarding CCTVs and their use of it for surveillance purposes. So,
I've seen people present at retail conferences where they've used cameras from shops, where they get permission from the retailer, maybe the manufacturer. They put a tiny little sign somewhere as you enter the shop, which people don't read, but there they've declared that you're going to be recorded and possibly used for research purposes. And then these things are turned into insights. And that is no different to CCTV in many respects. And it's also a challenge to the laws of many markets that we're all kind of filmed doing stuff anyway, everywhere. And so, you know, you can't have one rule for a government and another rule for a market research industry.
So Big Brother is in our pocket now.
Well, I mean, for not everything is personal data, right? So if you're a security company looking whether someone is putting the book into its bag and walking out the store, that usually isn't personal data. You're not identifying the individual just like that. And usually there are exceptions, even if you were collecting that information for, you know, for investigation, for those purposes. And of course, you can also rely on those notices, you know, which would then be giving them implied or deemed consent. I think the problem is when you start to match those pieces of data for a completely different purpose altogether.
Stitching, data stitching, perhaps?
Well, you know, you're just matching the face to the purchase to then for a purpose for marketing.
And frankly, there are a lot of marketers who are putting surveys on their marketing apps. And we know a lot of those folks. Shopkick does it, and they're not researchers. So and I think there's even a blend. We talked about it a little bit yesterday. More and more researchers are thinking about adding marketing to their apps. So the lines are blurred. We're trying to put some stake in the sand. Pandora's box has been opened. I think we're just trying to figure out the shape and size of that.
I mean, to the point about, you know, whenever a body says, are we putting restrictions on ourselves, making it hard for us to sell, do business, look at it from the other side of the coin. That can be a differentiating factor between you and someone else who doesn't. And that you can use that in your discussions with whoever is interested in talking to you.
Excellent closing statement. Does anyone else have anything to add to that? Me neither. Guy, back to you.
Thank you very much. Okay, we'll move on. Thank you very much.